Hello viewers, in the last session we discussed Memorandum of Association and alteration of Memorandum of Association. In this session we are going to discuss Articles of Association and Constructive Notice. The objectives of the lesson are: A. To explain about the Articles of Association, B. To explain the powers of officers of the company, C. To explain the binding force of memorandum and articles, D. To explain the doctrine of constructive notice and its exceptions. Articles of Association. Articles of Association are the rules, regulations and bylaws for the internal management of the affairs of the company. Articles are subordinate to the memorandum of the company. Memorandum defines the powers of the company and articles defines the powers of officers of the company. According to section 2, subsection 2 of the Act, articles means articles of association of a company as originally framed or as altered from time to time are applied in pursuance of any previous company law or of this Act. According to section 5, subsection 5 of the Act, the articles of a company shall be in respective forms specified in table F, G, H, I and J in schedule 1 as may be applicable to such company. A company may adopt all or any of the regulations contained in the model articles applicable to such company. According to section 6 of the Act, any provision contained in the memorandum, articles, agreement or resolution shall, to the extent to which it is repugnant to the provisions of this Act, become void. Table F is applicable to companies limited by shares. Such a company may either frame its own articles or adopt table F, and the table automatically applies to the extent to which it is not excluded. Form and signature of articles. Articles to be registered and must be printed. They should be divided into paragraphs, each consisting generally of one regulation and numbered consecutively. Each subscriber of the memorandum has to sign the document in the presence of at least one attesting witness, both of them adding their addresses and occupations. According to section 7 of the Companies Act 2013, a public company limited by shares may register its articles of association signed by the same subscribers as those of the memorandum, or alternatively it may adopt all or any of the regulations contained in table A of schedule 1 of the Act. If the articles are not registered, table A applies automatically, and if registered, table A applies except in so far as it is excluded by the articles. This provision applies to all companies limited by shares, whether public or private. The articles of a private company must incorporate the three restrictions as contained in section 2 subsection 68 of the Companies Act 2013. The articles of an unlimited company should state the number of members with which the company is to be registered, and if the company has a share capital, the amount of share capital with which it is to be registered, and in the case of a company limited by guarantee, the articles must state the number of members with which the company is to be registered. Where after the incorporation of a company, it is proved that the company got itself incorporated by furnishing false or incorrect information in its articles, then the company and the persons making such fraudulent information shall be liable to action under section 447 of the Companies Act 2013. Section 448 provides punishment for false statement. It is imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine which may extend to 3 times the amount involved. In case the company desires its shares to be quoted in a stock exchange, it must keep in view the stock exchange requirements while framing its articles. Alteration of articles. 1. The article should not contain any clause which is contrary to the memorandum or the provisions of the Companies Act 2013 or any other law in force. 2. The alteration must be bona fide and for the benefit of the company. 3. The alteration must not constitute a fraud on the minority of the company. 4. According to section 14 of the Act and the conditions contained in its memorandum, if any, a company may, by special resolution, alter its articles, including alterations having the effect of conversion of a private company into a public company, or B, a public company into a private company. 5. Any alteration having the effect of conversion of a public company into a private company shall not take effect except with the approval of the tribunal, which shall make such order as it may deem fit. 6. The NCLT may order a company to alter its articles with a view to resolving complaints against oppression and mismanagement in the company on an application made under section 241 or section 242 of the Act. The alterations made under an order of the tribunal shall have the same effect as if they were made by the company in accordance with the Act. The company must file a certified copy of the order with the registrar within 30 days of the issue of the order. 7. In Walker versus London Tramway Company, 1879, 12, Chancery Division, page 705, it was held that the right to alter the articles being unfettered, the company cannot in any manner, either by express provision in the articles or memorandum or by independent contract, deprive itself of the power to alter its articles. 8. A company is not prevented from altering its articles even if such an alteration would result in breach of some contract. 9. The articles may be altered with retrospective effect. Binding force of memorandum and articles. According to section 10 of the Act, the legal effect of the memorandum and articles, when registered, bind a company and the members thereof to the same extent as if they had been signed by the company and each member. In other words, the memorandum and articles of the company, when registered, bind the members to the company and the company to its members, but only in the capacity of members of the company and not in any other capacity such as directors, etc. The law may be stated in terms of the following propositions. A. Binding on members in their relation to a company. B. Binding on a company in its relation to members. C. Binding between members in their relation to the company. D. But not binding in relation to outsiders. First point, A. Binding on members in their relation to company. The memorandum and articles constitute a contract which is binding on members in their relation to the company. Each member, qua member, that is, in his capacity as a member, is bound to the company by the provisions of the articles. In Borland Trustee versus Steel Brothers and Company Limited, 1901, 1 Chancery, page 279, the articles of a company contained a clause that on the bankruptcy of a member, his shares would be sold to other persons at a price fixed by the directors. B. A shareholder was adjudicated bankrupt. His trustee in bankruptcy claimed that he was not bound by these provisions and was therefore free to sell the shares at their market value. It was held that the trustee was bound by the articles as the shares were purchased by B on the terms and conditions of the articles. B. Company bound to its members. Just as members are bound to the company is equally bound to its members, since the articles constitute a contract between the company and its members. Therefore, a member can bring an action against the company for violation of any of the provisions of the articles. In Wood vs. Odisha Waterworks Limited, 1889, 1 MEG, page 385, Court of Appeal, the articles of the company contained a provision that the directors may, with the sanction of the company, at general meeting, declare dividend to be paid to the members. Instead of paying the dividend in cash to shareholders, a resolution was passed to give them debenture bonds. One of the members of the company brought an action to restrain the directors from acting on the resolution. Justice Sterling held that the language of the provision clearly indicate that the dividend was to be paid in cash and the debenture bonds proposed to be issued are not payment in cash. The directors were therefore restrained from acting on the resolution and not to issue debenture bonds in lieu of dividend in cash. C. Binding between members. As between the members inter se, the memorandum and the articles constitute a contract between them and are also binding on each member as against the other or others. Such a contract can, however, be enforced through the medium of the company. D. The company is not bound to outsiders by the provisions of the articles. The articles bind the members to the company and vice versa, but neither the members nor the company is bound to outsiders to give effect to the articles. The term outsider signifies a person who is not a member of the company. The articles do not confer any contractual right even upon a member in a capacity other than that of a member. No articles can constitute a contract between the company and a third person. In Brown vs. Trinidad 1887, 37, Chancery Division 1, the articles of association of a company contained a clause to the effect that B should be a director and should not be removable till after 1888. He was, however, removed earlier and had brought an action to restrain the company from excluding him. It was held that there was no contract between B and the company. No outsider can enforce articles against the company even if they purport to give him certain rights. Even a member sometimes become an outsider, and in such a case, he cannot sue the company in his capacity as an outsider. In LA versus Positive Government Security Life Assurance Company, 1876, Law Reports 1, Exchequer Division, page 88, the articles of a company contained a clause that the plaintiff should be the solicitor of the company and should not be removed from his office unless there was misconduct. He was a member also. He acted as a solicitor to the company for some time, but ultimately the company substituted other solicitors for him. He brought an action against the company for breach of the contract in not employing him as a solicitor on the terms of the articles. His action was dismissed. Even a member cannot enforce the provisions of articles for his benefit in some other capacity than that of a member. Alteration in breach of contract. In Chidambaram Chettiar versus Krishna Iyengar, Indian Law Reports, 1910, 33, Madras, page 36. A clause in the articles of a company provide 250 rupees a month as the remuneration of the company secretary. The plaintiff accepted the post upon those terms. Subsequently, the company modified the articles and reduced the secretary's pay to 25 rupees a month. It was held that anyone accepting an appointment purely on the terms of the articles takes the risk of those terms being altered. But where apart from the articles, the company has entered into an independent agreement, the company may repudiate it by changing articles, but it will be answerable in damages for the breach. In Southern Foundries Limited versus Shirlaw, 1940, appeal cases, page 701, the plaintiff was a director in the defendant company. In 1933, he was appointed as the managing director for a term of 10 years. In 1935, the defendant company was amalgamated with another company and new articles were adopted under which powers were taken to dismiss a director. It was further provided that a managing director's appointment would be subject to determination ipso facto if he ceased to be a director. Under these articles, the plaintiff was removed from the office of the director. He sued for the wrongful repudiation of the contract. It was held that the agreement was unqualified in regard to the terms of 10 years. The removal was therefore a breach of the agreement for which the employer must answer in damages. The court may even restrain an alteration where it is likely to cause a damage which cannot be adequately compensated in terms of money. In British Murex Syndicate Limited versus Alperton Rubber Company Limited, 1915, 2 Chancery, page 186, an agreement provided that so long as the plaintiff syndicate should hold 5,000 shares in the defendant company, it should have the right of nominating 2 directors on the board of defendant company. A provision to the same effect was contained in Article 88 of the defendant's company's articles. The plaintiff syndicate had nominated 2 persons as directors whom the defendant company refused to accept. An attempt then made to cancel Article 88, but an injunction was granted to restrain it. The contract clearly involved as one of its terms that Article 88 was not to be altered, that is, that the plaintiff syndicate, so long as it was held that the stipulated number of shares was to have a perpetual right of nominating 2 directors of the company. Doctrine of constructive notice of memorandum and articles. The memorandum and articles, when registered, become a public document. Therefore, anyone, whether a member or an outsider, who has dealings with the company shall be deemed to have notice of the contents of these documents. It is the duty of every person dealing with the company to inspect these documents and see that it is within the powers of the company to enter into the proposed contract. Presumption that outsider has read memorandum and articles. Lord Hatherley observed in this regard in Mohani versus East Holyford Mining Company, 1875, Law Reports 7, House of Lords, as follows: but whether he actually reads them or not, it will be presumed that he has read them. Every joint stock company has its memorandum and articles of association open to all who are minded to have dealings whatsoever with the company, and those who so deal with them must be affected with notice of all that is contained in these 2 documents. In Kotla Venkataswamy versus Ramurthy, AER 1934, Madras 579, a South Indian and an industrial company provided in its articles that all contracts entered into by the company must bear the signatures of its managing director, secretary and executive director. The petitioner obtained a bond from the company which was signed only by the secretary and executive director, held that the bond having not been signed by the managing director, it could not be enforced against the company. Dear viewers, in this lesson, we discussed about articles of association, alteration of articles of association, binding force of memorandum of association, and doctrine of constructive notice. I hope you enjoyed this session, and we will meet in the next session.